Ronald Reagan's key campaign promises upon assuming the presidency in 1981 was to reduce the size and influence of the federal government and to promote deregulation in order to stimulate the economy. Today, the so-called administrative state, this is what is used derogatorily, is a huge piece of our federal governing system. Under the executive branch, there are 15 departments: Department of State, Treasury, Interior, Education, Agriculture, Justice, Commerce. They go on. And within those departments, there are more than 400 agencies and sub-agencies that employ 2 million Americans. Now, these agencies, among other functions, are the regulatory bodies upon which we rely in nearly every aspect of our daily lives. Experts at the EPA regulate pollutants. The Department of Transportation comes up with safety standards for cars and highways. Agriculture makes sure our food is safe. FDA determines the drugs we consume. OSHA and the Department of Labor keep workers safe. They protect their rights. This big, complex nation has big, complex systems to keep it running. But for decades, even before Reagan gave that speech, there have been debates about the size of government and the democratic nature of accountability, often in conservative circles. In 2018, as Trump had already appointed an historic number of federal judges, including his first Supreme Court pick, Neil Gorsuch, who had a long history of opposing federal regulations. The White House counsel, Don McGahn, said in plain terms exactly what the Trump administration was going to do. Quote, there is a coherent plan here where actually the judicial selection and the deregulatory effect are really the flip side of the same coin. With courts stacked with Trump appointees across the country, the coherent plan was well underway. The Supreme Court has taken up 3 major cases this term that take aim at the very structure of the so-called administrative state and at the constitutionality of how they function. These cases on their own, but especially together, will call into question the function of our government as we know it. Today, we're focusing on one of those cases, SEC versus Jarchesi. In short, George Jarchesi is a right-wing activist and political commentator who is also a hedge fund manager. He got in trouble with the Securities and Exchange Commission for fraud. The SEC found that he misrepresented how his funds were run, that he paid himself and his partner excessive fees, that he inflated his assets' value. The SEC responded in a very standard way, fining him and prohibiting him from certain kinds of investment work. Jarchesi contested the SEC's ruling, but he didn't stop there. He argued that the SEC's entire regulatory process, including the role of administrative law judges, was unconstitutional. SEC versus Jarchesi and the other 2 cases taken up by the Supreme Court take aim at the powers of the so-called administrative state and at the very functioning of our government. They attack the constitutionality of how agencies are funded. They attack Congress's ability to delegate responsibilities to the agencies, and they attack the constitutionality of how agencies are allowed to adjudicate matters. Just last year, the Supreme Court ruled against the EPA in a decision that severely limited agencies' regulatory power. In that case, the EPA's ability to regulate carbon dioxide. Justice Elena Kagan wrote in the dissent in support of the EPA, saying that the court, quote, does not have a clue, I'll read it here, does not have a clue about how to address climate change, yet it appoints itself, instead of Congress or the expert agency, the decision maker on climate policy. I cannot think of many things more frightening, end quote. The fact that the Supreme Court has even agreed to hear the SEC case and other cases that threaten the administrative state is alarming. It signals the court's appetite to tear down or at least chip away at a crucial check and balance of the American government. Without the full use of these federal agencies, who prevents insider trading? Who makes sure we have clean air and water, that our food is safe to eat, that our roads are up to snuff? And by the way, this whole effort to dismantle the administrative state would hand even more decision-making power and more responsibility to the Supreme Court and to Congress, a Congress that is notoriously incapable of deciding much of anything at the moment. The question is, do we want agencies staffed with experts in their respective fields to design and enforce regulations for how we operate, or do we want Congress and a few appointed judges to make those decisions? These cases do not have the same name recognition or obvious immediate consequences as other landmark cases we've seen this Supreme Court deliver in the last few years, like the Dobbs decision to end the right to abortion or its decision to overturn affirmative action. But these cases cannot go unnoticed. These are cases that have the potential to upend systems upon which we rely to protect ourselves, our water, our economy, our food, and our planet. Joining me now, Melissa Murray, a professor at NYU, co-host of the Strict Scrutiny podcast, and an MSNBC legal analyst. Melissa, great to see you. I've talked enough about this, and I don't know if I've done justice in explaining, because it's not something that is in the ether. People don't think about the administrative state all that much, regular folks. But this is a long-term effort to cause one of these cases to be successful. And then what happens? What happens if the SEC rules that, yeah, Mr. Jarkissi, you're right, the SEC or the way it handles things are unconstitutional?
So first of all, that was an amazing explainer, Ali, really terrific. And I'm so glad you're covering these cases, because you're exactly right. They have floated under the radar, but they have the real potential to completely upend the way government as we know it runs. So the case, SEC versus Jarkissi, involves the Seventh Amendment right to a jury trial, as well as some other constitutional issues. The court, in oral argument last week, focused primarily on the Seventh Amendment, which guarantees individuals a right to a jury trial in civil cases. The court had addressed this question of whether agencies could have administrative tribunals to make determinations of how the laws were followed in an earlier case from 1977 called Atlas Roofing. In that case, the court said that where the circumstances involved common law claims among private parties, those had to be tried consistent with the Seventh Amendment's right to a civil jury trial. However, where the case involves so-called public rights, that is, where the government was enforcing public laws and enforcing the public's rights to compliance with those laws, including the right to fair markets, fair and safe markets, well, then those could be tried in administrative tribunals. And then the parties had the opportunity to have those administrative tribunal determinations reviewed in a federal court. This is the entire crux of what is being challenged in Jarkissi. Mr. Jarkissi was tried by an administrative tribunal, determined that he violated the securities laws, and a penalty and fine was imposed. He now challenges that on the ground that it violates his right to a civil jury trial. Atlas Roofing, that 1977 case, would appear to answer this. This is a government bringing the case to enforce public laws and public rights. But the Supreme Court last week seemed really interested in whether or not this was tantamount to government tyranny, and Mr. Jarkissi needed someone like this court to step in and enforce his right to a jury trial. And as you note, there's a lot riding on this. Almost every administrative agency has these administrative tribunals for determining violations of the laws that they are charged with regulating. So it doesn't just affect the SEC, it affects a lot of administrative agencies. More importantly, it will have a huge impact on how the SEC enforces the securities laws. Right now, the federal courts are absolutely overburdened, which means that if the SEC wants to enforce securities actions, they're really going to have to triage and prioritize the most important cases that should go to the federal courts, because right now it's just taking so long to get things through to a jury trial there. So the SEC is going to have to pick and choose, and that means a lot of things may go unenforced, which seems to be exactly what corporate interests want.
And there's an impression for those who are critics of the administrative state that somehow this skips the normal justice system. It skips the normal congressional approval system. But that's not true, because every one of these government departments is populated by people who are congressionally approved. Every one of these agencies is headed by somebody who is congressionally approved. So if you suddenly think the SEC is going rogue or the EPA is going rogue, Congress does actually have recourse in this thing. But they would have you believe that all of these agencies are just, in the same way that people criticize the deep state, the administrative state is just its own thing with its own laws. In fact, it's got more to do with sort of efficiency and expertise, right? That federal courts are clogged.
That's exactly right.
And these are experts.
No, that's exactly right. And again, a lot of the things that administrative agencies do, conservatives argue that these things should be done by Congress. But could you imagine asking Congress right now to make regulations about particulate air matter and what's safe for clean water? You couldn't. And more importantly, this whole question of a lack of accountability, especially in the context of the civil jury trial right, really doesn't make sense, because these administrative trial tribunals are not the last word. The parties can always appeal the determinations of the tribunals to the federal court. So again, it's not as if this is judge, jury, and executioner. There's a system and although these agencies are often insulated, they're not completely unaccountable. And in fact, they're actually necessary for the kind of efficiency and efficient government and good government that we're used to.
Yeah, it's also used around the world, like in working democracies everywhere. This is how governments apportion how they regulate and how they decide things. Melissa, great to see you. As always, thank you so much for